Third-party proceedings continue to be a source of stress and confusion for BC lawyers. Here are a few reminders on this sometimes quite vexing topic. Firstly, a few comments on the rules of court. Rule 3-5 sub 4 was recently revised to allow more time to file third-party notices. Now you have a bit more breathing room. Time starts to run not from the date of service of the notice of civil claim, but rather from the date you filed your response. Now you have up to 42 days after filing your response to file your third-party notice without leave of the court. There was also some question as to whether you could only seek contribution and indemnity by way of third-party notice. After all, Rule 21-9 says that if a defendant is claiming such relief under the Negligence Act, they must do so by way of third-party notice. Recent case law has confirmed, however, that Rule 21-9 only addresses the procedure for seeking this relief within the existing action. The rule does not prohibit a defendant from seeking contribution and indemnity by filing their own separate notice of civil claim. Now let's talk about limitation periods for third-party claims. The Court of Appeal has confirmed in the Sohal case that there is a strict 2-year limitation period from the date the third-party claim is discovered. Section 16 of the Limitation Act says a claim for contribution or indemnity is discovered on the later of either the day on which the defendant knew or ought to have known they could make a third-party claim, or the day the defendant is served with pleadings on which the third-party claim is based. There is recent case law indicating that those pleadings could be from a separate matter, thus in some cases extending the running of a limitation period for a longer time. The law in this area continues to evolve, and we are watching it closely. Your best approach, of course, is to avoid a potential problem by filing early. Next, consider whether a third-party claim is necessary. You may not need a third-party notice if there is no issue of joint liability between your client and the other party, nor any concern that your client could be left paying more than its share. Remember that if it's simply a matter of apportionment, you can plead that in your response. You will want to consider third-party proceedings, however, in the following situations. If you have a concern that damages are indivisible, insurance limits may be inadequate, and/or there could be jointly liable tortfeasors with different abilities to pay. You will want to consider a third-party notice in these situations. Another example, your client says the responsibility for the loss flows through them to another party, say someone with whom they have contracted to assume that responsibility. A further example is when there is a contractual indemnity clause between your client and someone else. Finally, third-party proceedings are generally not appropriate where your allegations relate to some duty or obligation of the plaintiff, such as mitigation. An example here is that third-party actions usually cannot be maintained against the plaintiff's lawyer or some other agent of the plaintiff. These allegations are properly raised directly against the plaintiff. Any concerns that you've made a mistake or that you have a limitation problem? Give us a call. We will review your situation and we'll help you figure out next steps.